The second item for proposal for decision is on Dr. Mary Tally Bowden. Mr. Carlton can go ahead and proceed.
Yep, it'll be the same as the last one you just heard. So I did see, I believe, Dr. Bowden online, so that's good. She's here with us today, and I'm sure she has counsel with her too. But same setup, board staff and Dr. Bowden will both have 10 minutes to make their comments to the board. Board staff will go first, and then they may reserve their remaining time for any rebuttal, and you may begin.
Thank you, Mr. Carlton. Amy Swanholm on behalf of board staff. Good morning, board members. You have in front of you today for your consideration a proposal for decision, or PFD, and a proposed final order for Dr. Mary Tally Bowden. This order is, as required by law, based on the PFD, is issued by the judges of the State Office of Administrative Hearings. The board has no authority to change the findings in the PFD, only authority to determine the appropriate sanctions based on the PFD. As background, board staff filed this complaint in April of 2023, and after a series of continuances, board staff filed 2 motions for summary disposition. The first one was denied, and the second one was granted in part. Based on the second summary disposition, board staff proceeded to move forward solely based on the substantive violations found in that second summary disposition. In that decision, the SOAH judges found that Dr. Bowden had engaged in unprofessional conduct by attempting to treat a patient at a facility where she did not have medical privileges. Essentially, at this point, the substantive part of the proceeding was concluded, with findings in favor of the board. The next step in the proceeding then was to hold a hearing solely for the purpose of considering evidence related to sanctions, a hearing solely on aggravating and mitigating factors. These are factors that would potentially aggravate or worsen any proposed sanctions or mitigate or lessen any proposed sanctions. That hearing was held on April 28th, 2025. Board staff did not present any witnesses, but moved forward on documentary evidence and on examination of Dr. Bowden and cross-examination of Dr. Bowden's witnesses. The judges issued their decision on August 7th, 2025. Both parties filed exceptions. No changes were made to the PFD. In that decision, the judges reiterated their findings from the summary disposition, that Dr. Bowden behaved in a disruptive manner by sending a nurse to a hospital where she did not have privileges, and the judges found 2 aggravating factors and no mitigating factors. The aggravating factors found by the judges: Dr. Bowden's actions were intentional. Dr. Bowden's unprofessional conduct presented an increased potential for harm to the public. Those are the judges' words. Board staff has submitted for you a proposed order that's based on that PFD, with one ordering provision, a public record. The remainder of the provisions are standard ordering language. You have in front of you that order today for your consideration. We ask to remain the remainder of our time to be held for rebuttal as necessary, and we ask that you vote to approve the order. Thank you.
Okay, thank you. Dr. Bowden and your attorney, you have 10 minutes to make your comments to the board. You're still on mute. If you can unmute yourself. There we go. Still muted.
Okay. Can you hear me?
Yes, we can. Thank you.
All right. Well, first of all, I wish I were there in person, but I only found out I could be there in person yesterday. So, because, for the past 4 years, it's all been virtual because of infection concerns. This was a very unique situation. I'd never been in this ever before. I doubt I'll ever be in this again. I don't think the board has ever had this situation. Background, this was the 3rd largest surge of the pandemic. This was 9 months following the rollout of the COVID shots. This was, 5 months after Houston Methodist mandated the COVID shots. This was a month after Biden mandated the COVID shots. And I'd never been so busy in my life. Treating COVID patients all day long, 7 days a week. I got basically 4 years ago, almost to the day, I got a phone call from Aaron Jones, frantic, Texas Sealy Hospital, was talking hospice, wanted to let him die, and she wanted him to try a drug that is now over the counter in Texas, ivermectin. asked me to help. I did what I could. It was a very complicated legal situation. I testified. We won. The court did not offer Texas Chigley Hospital any discretion in whether or not to give me privileges. So I was following a court order. I had a duty to my patient, and that's what I did. I followed the advice of my patient's attorney. I should have probably gotten my own attorney, but beyond that, I have absolutely no regrets. I would do it all over again, without a doubt. I'm actually proud of myself for what I did. And so is a Texas legislator. They issued a resolution honoring me. So going forward, I don't really care what y'all say today. I am appealing. I am suing. I have 2 lawsuits that will be served probably next week to the board, to members of the board individually. I will be working on legislation so that this never happens again, because patients should not have to sue to get a second opinion. It's absolutely ridiculous, especially during a pandemic where doctors were given same-day privileges. If they showed up at the hospital and said, I'm here to help, same-day privileges, but not me. And it said nothing to do with ivermectin, nothing to do with ivermectin, right? That's why my deposition, they named ivermectin 86 times. Let's just say, Mr. Jones wanted to get a second opinion. Just bring Dr. Bowden in for a second opinion. Well, still, he had to sue, and they wouldn't let me do it. I had a clean record, no malpractice, never been in front of the board, never thought this would ever happen. So I don't really care what y'all say. This is going forward. I'm taking it all the way. Thank you.
Well, thank you for your comments. Board staff, you have 7 minutes and 5 seconds remaining.
Sure. Just a few notes in response to that. Dr. Bowden's comment that we won is inaccurate. She is referencing a procedural win that they did have, but that procedural win was stayed by the Court of Appeals, which is discussed in the PFD. And if you would like me to go into detail on that, I'm happy to do so. She did make the argument that she was following the advice of the attorney at the hearing on the merits. However, that argument was rejected by the administrative law judges, and they did find that that was not a mitigating factor that you could consider today. Happy to answer any questions if the board members have them. Thank you.
One point of clarification was you said there was an appeal on the procedural issue she was talking about. Did that appeal happen before or after the date in question of attempting to treat the patient?
So the appeal was made after the TI was issued, and the appellate court stayed the temporary injunction order prior to the events at issue, prior to the nurse being sent to the hospital.
Which I did not have any knowledge of, which you know exactly. I had no knowledge of that, which you actually acknowledge that. So you're lying by omission, Amy.
Sure.
Thank you for that clarification. Board
Absolutely.
members, any questions for the board members?
All right, so you've heard both sides. Are there any questions by the board members to either Ms. Amy or to Dr. Bowden? Are there any recusals on this item? All right, seeing none, is there a motion on this item?
Dr. Zafran, I'd like to make a motion.
Dr. Quinones?
I'd like to make it actually a 2-part motion. Shall I make them separate or shall I make them together?
Make it as one single motion, please.
Yeah, you
Very
can
good.
together.
I move that the board enter a final order that adopts the findings of fact and conclusions of law recommended by the administrative law judges in the proposal for a decision. I further move that based on the findings of fact and conclusions of law, the board issue a public reprimand, and the public reprimand is the only term in the final order.
Thank you, Dr. Quinones. A motion's been made. Is there a second?
Vanderwacht, second.
And seconded by Dr. Vanderwide. Is there any further discussion on the motion? All right, seeing none, all those in favor, please say aye.
Aye.
All those opposed? Those who are virtual, we got that too?
Yes, I believe we got everyone's votes in person and virtual.
All right, motion passes. Thank you.